Shanley versus Weber and Olzese PC, Michael Olzese, Suzanne Barta, Michael Kirschenheiter, Jeffrey Werber, and Sandra Francis individually, which really should have been entitled a third party. Your appearance?
Good morning, Judge McNally. Suzanne Barta, P65425 on behalf of Bank of America.
Your name, sir?
I, Patrick Shanley, am before this court by special appearance.
Hang on,
without waiving
hang on.
any rights, remedies,
Mr.
or
Shanley,
defenses.
Mr. Shanley.
I am not waiving defects of services, nor am I submitting to the jurisdiction.
And right here we hit the classic courtroom trope. I don't submit to jurisdiction. Judges hear this all the time. The problem? Courts don't stop being courts just because someone says magic words.
Nor am I submitting to the jurisdiction of the court or the alleged plaintiff in this cover of law action.
I didn't ask you that.
I reserve all my God-given rights. I waive.
Let me let you in on the secret. I'm going to listen to you, but I'm not going to play games. I asked you for your appearance. I read your briefs, period. I didn't ask you to go on like that.
This is the judge drawing a hard line early. Translation. I've read your paperwork. I'm not impressed, and I'm not here to debate internet legal theories. Control of the courtroom is already locked in.
To go on like that, don't do it again. But you can proceed on your motion to dismiss counterclaim. Congratulations, Mr. Shanley. That's the first time I've used that in years. Go ahead.
Your Honor, I'm hoping this ends today. There are two motions before you. One is to quash the matter against Weber and Olzese and the 5 named defendants from my office. I believe the last time you were here, brother counsel, Mr. Werber, that was here, he advised me that you told Mr. Shanley that he needs to hire an attorney because he was treading on some dangerous water. And he has not hired an attorney.
Well, I didn't say he needed to. I strongly suggested that he do that.
Because he was treading on some dangerous water in the claims that he's making. We're asking for the matter before Weber and Olzese and the 5 named attorneys to be dismissed at this time, Your Honor.
If you don't mind, I'd like to take the motion to dismiss the counterclaim first. It was filed, and I understand there could be reason for confusion. Your office filed 2 separate motions. You filed a motion to dismiss the counterclaim, which focused on the claim that Mr. Shanley has against Bank of America as Bank of America being counter-defendant. And then you filed a motion to quash summons and dismiss 30 third-party defendants on the claim that Mr. Shanley has against the law firm Weber and Olzese PLC, which really should have been, as you know, a third-party complaint, and then as against the individual lawyers that I already mentioned, which would include yourself, Michael Olzese, Michael Kirschenheiter, Jeffrey Werber, and Sandra Francis. So let's proceed first.
I object.
You can object all you want. Let's proceed with the motion to dismiss counterclaim.
I object.
I'm telling him I want him to argue that one first, Mr. Shanley. What are you objecting about, besides the fact you just want to get loud?
I have my affidavit before you, the paperwork. That's what matters in this case.
Mr. Shanley, I have 2 motions. I'm going to listen to what you have to say. I'm telling him I want him to first proceed with his motion to dismiss the counterclaim that they filed pertaining to your claim against Bank of America. Then after that is argued by both parties, he can go on to the motion to quash the summons and dismiss the third party purported counter defendants or third party defendants, both the law firm as well as the individual defendants. That's all I'm saying, sir. There's no reason to object about anything here. And by the way, Mr. Barta, on your motion to quash the summons and dismiss all third-party defendants, you have an attachment. The verification of debt is attached to your motion as set forth. It appears on Exhibit 1. And it is unsigned. And it looks like it was going to be, at least my copy that was provided to me is unsigned. I'm talking about the verification of debt that appears was going to be signed by somebody from Bank of America. Do you have an executed copy?
No, Your Honor, they would not execute that copy. That was provided for by Mr. Shanley.
I see.
That's an affidavit that he provided that he wanted signed
I
by
see.
Bank of America.
I misunderstood. Go with your motion.
Your Honor, our motion, we're gonna rely on our written brief. However, I'm gonna make it very short. He solely relies on that verification was not met by Bank of America, but Bank of America did validate.
I object. He can't
Sir,
speak for a
sir.
fiction.
Sir. This is a courtroom and we show one another courtesy. You will have an opportunity to respond to whatever he has to say when he's done, okay? Be glad to give you all the time you need. Go ahead.
Your Honor, Bank of America is not considered a debt collector, and the FDCPA only pertains.
Key legal
to debt.
reality check. The FDCPA applies to debt collectors, not original creditors. Bank of America issued the credit, so this entire claim is hanging by a thread. Did you catch how fast that argument unraveled?
Only pertains to debt collection companies. So the FDCPA does not apply to Bank of America. And his sole claim is that there's a violation of the FDCPA. But if Bank of America were deemed to be a debt collector, they still verified the debt to Mr. Shanley and sent all relative documentation. The fact that they did not provide Mr. Shanley what he believes they should have given him is not a violation in and of itself as well. So, and that's the sole reason he filed his counterclaim against Bank of America. And it just does not hold water at its time.
Give me 1 second. I need to. All right, Mr. Shanley, your response.
Have you read my affidavit, sir?
I'm not a witness. I'm the judge. Of course, I've read everything in this brief.
Everything I have to say is in my paperwork in there.
So here's what I'm left with. On July 21 of 20, it appears to the court that the defendant counter plaintiff entered into a contract with plaintiff counter defendant Bank of America. Bank of America provided credit to Mr. Shanley. Defendant counter plaintiff made some payments thereon. That forms the basis of a contract. They do not have to produce or provide a written contract. A contract is formed when in the line of when in a credit card situation, somebody utilizes the card.
This part matters a lot. Using a credit card is the contract. No signature required. No paper agreement needed. Swipe the card, accept the terms. Courts across the country agree on this.
That is when the contract is formed between the parties. On December 5, 22, Bank of America initiated an action against the defendant counter plaintiff. Defendant filed a responsive pleading and a counterclaim against Bank of America. The counterclaim alleges violation of the Fair Debt Collections Practices Act, FDCPA. Also, the claim is that Bank of America failed to validate the account. Court is going to rule in favor of Bank of America and dismiss the defendant/counter plaintiff's counterclaim versus Bank of America for the following reasons. Bank of America is a creditor. They are not a debt collector, and they're not subject to the FDCPA. Therefore, as such, he failed to state a claim upon which relief can be granted, and their motion is granted pursuant to MCR 2.116C8. Moreover, there's documentation attached to the counter defendant's response that indicates that Mr. One of the lawyers, I will find that in a moment, find that one of the lawyers did in fact send, I'm talking about from the Weber Olsey's law firm, did in fact send in return a document which would have satisfied validation of the debt. Therefore, pursuant to MCR 2.116C8 and C10, counter defendant, Bank of America, is entitled to a summary disposition, and again, on the basis that the counter plaintiff failed to state a claim upon which relief could be granted against this particular party, and or there's no genuine issue as to any material fact. So I'm granting that motion to dismiss the counterclaim. Now, you can proceed with your motion to dismiss the law firm as well as the individual defendants.
Your Honor, that matter, I believe, is in practicing law for 20 years is never been done before. It's the first time. It's frivolous. There is no cause of action against Robert Olsey's, Michael Olsey's, Suzanne Barta, Mike Kirschenheider, Jeffrey Werber, and Sandra Francis. And we're relying on that written brief as well. However, we're not only asking for an order dismissing the case against all third-party defendants with prejudice, we're also asking for sanctions.
That's okay. Go ahead, I'm sorry.
So we're also asking for sanctions, Your Honor.
Well, I'm not going to get to sanctions unless and until I rule in your favor on this. Do you have any response? You can continue if you're.
No, I mean, the only thing I would say, Your Honor, is validation took place again. I think that's a sole source, is that there's a violation of the FDCPA. The validation requested on his documents has a different file number because there's a second case. So we're not even talking about Mr. Shanley's request for validation on this particular case. He put a different file number on it, and that case is coming down the pipeline. But as to this case, I'm asking Your Honor to please rule in our favor and put an end to this. We put a lot of time and effort responding to this frivolous action.
Do you have any response?
Your Honor, I've submitted my affidavit, which rebutted their Bank of America. My paperwork reads for itself. All that other stuff was hearsay. I have this affidavit. Are they gonna rebut my affidavit.
Okay. Do you have any response to that, counsel?
No, Your Honor.
Your affidavit talks about you're not an artificial person. Affidavit of status of Patrick Allen Shanley, right? What are they supposed to rebut in here? You're referring to the affidavit attached to your motion to dismiss, supported by affidavit of that Patrick
Yes.
Shanley? Okay. All right. Well, you guys can have a seat. Again, on this case, motion to quash summons and dismiss all third-party defendants. Court finds that on July 21 of 20, defendant and plaintiff entered into a contract. The plaintiff provided credit. Defendant paid some of the monies due and owing on the credit card debt, but defaulted. On December 5, 22, plaintiff initiated an action. Defendant filed a responsive pleading, a counterclaim, and named all lawyers as third-party defendants, actually as counter defendants, but they should have been properly named as third-party defendants. The plaintiff, Bank of America, or I should say, in this case, the motion filed by defendant law firm and defendant lawyers claims that the defendant, Mr. Shanley, did not file a third-party complaint as required pursuant to MCR 2.204. They allege that the addition of the third-party defendants in the counterclaim violates 2.110C, as only a cross-claim or counterclaim can be filed with an answer. And they further claim that 2.204 requires a separate third-party claim. In addition, that they claim that Mr. Shanley's counterclaim against the law firm of Weber and Olsees and against the individual defendant lawyers is without merit. They claim that the asserted claims do not show a violation of the Fair Debt Collection Practices Act because, number one, he did not send a request, Mr. Shanley did, for validation to the individual third-party defendants. That it was only sent to the law firm of Weber and Olsees. Second, that as it relates to the law firm of Weber and Olsees, that a letter was sent with supporting documentation, thereby validating the account. That is the claim. And I will just say this. To begin with, defendant's third-party complaint was filed improperly. Initiation of an action against the law firm of Weber and Olsees PC and individual attorneys with that firm should have been filed as a third-party complaint. Neither the law firm Weber and Olsees PLC nor the named individuals were parties to the principal complaint, and therefore the pleading should have been filed as a third-party complaint, naming the law firm itself, Weber and Olsees PLC, as well as individual defendants, Michael Olsees, Suzanne Varda, Michael Kirschenheiter, Jeffrey Werber, and Sandra Francis as third-party defendants.
Here's where it quietly falls apart. The judge is saying, even if I fix your filing mistakes, your case still goes nowhere. That's devastating because it means procedure isn't the problem. The facts.
Make no mistake about it, though, the court would gladly permit, and I read Mr. Shanley's brief with regard to how pro se litigants should, in essence, have rules construed more liberally in their favor, so that if there's a technical violation of the court rules or a technical violation of filing of certain pleadings, that the court should permit it. And I have no difficulty permitting Mr. Shanley to file a third-party complaint in the proper form as against Weber and Olsees, PLC, and or against the individual defendants. However, the court must make a determination in fairness as to whether or not such a claim should be and could be possibly successful if the court were to allow somebody to file, in this case, Mr. Shanley, to file a third-party complaint. There is no evidence that defendant sent a request to the individual attorneys. No evidence whatsoever that would have required them individually to validate the debt to conform to the Fair Debt Collections Practice Act. There's no evidence at all anywhere that I saw in any documentation which leads the court to believe that Mr. Shanley or somebody on his behalf sent a request to the individual attorneys. There is evidence that it was sent to the law firm of Weber and Olsees. There is evidence that the law firm of Weber and Olsees, PC, responded to that request for validation. There's no evidence that the validation documentation submitted was invalid under the Fair Debt Collection Practices Act. I've told you, Mr. Shanley, they don't have to produce a contract. They don't have to produce a written contract. When you use the credit card, the contract is formed, period, plain simple. And then you're subject to the terms and conditions of the credit card agreement. In this case, first, as I said, there's no evidence that an individual letter was sent to the firm to the individual lawyers. Therefore, they weren't subject to the Fair Debt Collection Practice Act. Therefore, I'm granting summary disposition in their favor. In quashing the summons and dismissing the third party or the counterclaim filed against them. Moreover, Weber and Olsees, who would have been subject to the validation language of the FDCPA because they were specifically sent a request, responded. There's no genuine issue as to any material fact here. There's no specific facts that the counter plaintiff has come forth with to establish a factual issue as to whether or not there was a violation. So therefore, defendants, third part, I'm going to say counter defendants, Weber and Olsees, Michael Olsees, Suzanne Barta, Michael Kirschenheiter, Jeffrey Werber, and Sandra Francis are granted summary disposition. The summons is quashed and the third party complaint / counter complaint is dismissed. Now, that concludes this hearing. You wanted to move for sanctions. What do you have to say about that?
Your Honor, other than the time and effort that has been put into this matter in responding, there's another case coming down the pipeline. I don't know if Mr. Shanley's been served with that case. It's another Bank of America case. If you do not award sanctions of any kind, then I don't believe it would be fair for the attorneys in my law firm at Weber and Olsees to have to put additional time and effort on the next case. So I believe it's imperative that you grant the sanctions at this time, so that this doesn't happen again. Thank you.
Mr. Shanley?
Your Honor, the last time I was here, you lectured me on that I should
Get a lawyer.
get a lawyer and pro se. Okay, I'm not doing this pro se. I'm not representing myself. I am myself. I have an affidavit there that rebuts Bank of America's claim. It's in my paperwork.
I was trying to do you a favor, Mr. Shanley. I was trying to tell you, please consult with a lawyer so you don't proceed with lawsuits that are frivolous in nature and force the court to do something that I don't want to do. That's what my purpose was in telling you that you should get an attorney. You have every right to represent yourself, whether it's a $5 lawsuit or you're representing yourself because you're charged with a serious felony. Every defendant, every party in this country has the right to represent themselves, just like I have the right to give myself a root canal. I have the right to fix my arm. I wouldn't do it. I've told you nicely, I think on this case, I've only seen 1 or 2 people do it adequately in my 28+ years on the bench and my 11 years as a lawyer. But that's neither here nor there. You have that right. The problem is here that you're abusing this system. That's what you're doing. You are abusing this system. In my view, and the court finds that the primary purpose in initiating this action against these lawyers in this law firm was to harass, embarrass, or injure those individuals and that law firm. You had no reasonable basis to believe that the facts underlying the party's legal position were in fact true. And I'm finding that you advanced a frivolous claim.
This is the nuclear option, frivolous filing. That word opens the door to sanctions, real money, real consequences. So here's the question for you. Was this confidence or a costly misunderstanding of the law?
In conjunction with that counter complaint that you filed, period. I'm not going to award it on the counterclaim versus the bank. I am going to award sanctions on the counterclaim that was filed against the law firm and the individual lawyers. You don't get to do this. This is not some kind of a game. We don't think this is funny. I have a great sense of humor when I'm not in here. Not in here. This isn't some kind of an entertainment exercise. Now, the question is, what kind of sanctions are you entitled to? And that's what you're going to have to grapple with, because even though I think his conduct was outrageous, and I do think it was outrageous, and this record should reflect that this court finds the conduct was outrageous. But sanctions is a law firm entitled to when they represented themselves, Mr. Barr. Had you gone out and hired another law firm and paid them $400 an hour, a very experienced law firm would have no difficulty in awarding recoupment of those attorney fees. The question is, what kind of reasonable attorney fees is one entitled to? And what types of sanctions is one entitled to when they've represented themselves? So here's what you're going to do, please. And it does not have to be lengthy. You can do it by Zoom, but you're going to prepare an order granting the motions for summary disposition based on the grounds I stated previously, just here 10 minutes ago. Then I'd like you to file a motion. It doesn't have to be lengthy, but you're going to have to set forth what sanctions you believe that you're entitled to. To the extent that you believe that you're entitled to attorney fees, the law firm can set forth how much time was expended, what their hourly rate was, and why those attorney fees would be reasonable under the circumstances. But I have to tell you, I'm going back to whether or not it's appropriate for a law firm to collect sanctions that's representing itself on a frivolous action that's filed against it. My gut says it should be. My brain says I don't know that it can be. Am I making sense?
Yes, Your Honor. I believe if there wasn't a second file coming down the pipeway, I would be amenable to walking out of this courtroom and being done with this action.
Well, that's neither here nor there. I don't even know if that case is going to be assigned to me, and I'll rule if it is on the facts and the law pertaining to that particular case. That's up to you guys. But to the extent I'm going to grant your motion, you can put it right in there. The court finds this was a frivolous action. And so your order should say order granting summary disposition on the two claims. And you can put that in. And you can also add in finding counterclaim filed versus law firm and lawyers was frivolous within the meaning of the statute, MCL 600.25913A, I and 2, small I and small 2. And that the court is directing that you file a written motion and itemize your what costs and sanctions you believe you're entitled to. And again, you're going to have to focus a bit on whether it's appropriate that a law firm representing itself is reimbursed. I'm not getting into whether other cases should or shouldn't be filed. I don't, like I said, I don't even know if that case is assigned to me. Is it? Do you know?
I don't.
Do you know, Mr. Shanley? I'm sorry,
I do not know.
but that's the ruling. Any clarification needed?
No, Your Honor, if
Are you going to rule on my motion to dismiss?
I'm denying it for the reasons stated.
I object.
I know. It's okay, you can appeal. I'm not always right, Mr. Shanley.
Your Honor, I have two.
We have an established
Proposal.
jurisdiction.
All right, listen, I don't want to hear it. You can take all this transcript and go to a reviewing court.
I have
Go
two
ahead.
proposed orders. Can I present them?
Let me see them.
May I approach?
You can.
The top one is a proposed order dismissing the counterclaim against Bank of America. The second one is a proposed order dismissing the case with prejudice as to Weber and Olsey's and all named attorneys. If the court wishes to exclude the sanctions portion of that,
I'd prefer, I'll sign your order dismissing counterclaim with prejudice versus Bank of America.
I believe, Your Honor, Weber and Olsey's is not, there's a chance that we're not going to be filing the motion as to,
I still want the order to reflect what happened, and this doesn't do it.
okay,
So I want you to put in there, the court further finds, after you set forth the preamble, that I'm granting I'm dismissing the quashing the summons and dismissing the third party / counter complaint against the individual lawyers and the corporation, that the court found that the counter plaintiff's action filed against the law firm and the individual lawyers was frivolous pursuant to the meaning of 600, write that down, 600.2591. And that the court has invited the plaintiff to file, the lawyers and the law firm to file a motion for imposition of sanctions, itemizing that which they believe that they're entitled to.
perfect.
But But the court would, if you're going to ask for attorney fees, and I want it right in the body of the order, court's going to need authority to award attorney fees to a law firm that was representing itself. So that's it. I'm handing you the order on the top. You can keep the other order in the file if you'd like. And that is it. Linda, that's all right.
Yes, Your Honor.
Oh, that's okay. I got it.
Okay.
It's today, 13th.